We're on to question 3 for the July 2022 bar. In what I thought was an extremely difficult bar, several of these hypotheticals raised issues that are not normally seen in the essays, fairly picky issues. This one was the third essay on Tuesday, and it was a straight PR essay. You know that when you see answer according to California and ABA authorities. The call of the question asks for ethical violations, so I don't want to write about what the lawyer did right. I want to write about what the lawyer did wrong. I always have trouble organizing a professional responsibility answer, more trouble than contracts or property or wills or any of those subjects where the analysis is pretty vertical. It follow the facts, follow the history of whatever is going on. You can organize a PR answer that way by following the history of what happens in the hypothetical, but I think it's really effective to figure out what the main conflict is as you read through and organize your answer around that. Show the reader that you understand what the main conflict in the hypothetical was that led to the ethical violations. So I always try to do that. In this one, we have Clint hired Linda, a lawyer, to represent him in a personal injury lawsuit against Dan, the driver of the car that collided with Clint's car, thereby causing him serious bodily injury. So I don't have to set up the lawyer-client relationship. They give us that he has hired her. Clint could not afford to pay Linda. So Linda told Clint not to worry about paying anything until there's a recovery in the case. Linda told Clint that if a recovery is obtained, Linda would take 50% as her attorney fee, and Clint will get the other half, less any costs Linda incurred. So right here, I see the conflict. It's immediately set up in this hypothetical. It's a concurrent conflict of interest in that Linda's own interests in recovering a fee are going to affect her independent professional judgment in the rest of this hypothetical. She's going to get half, and Clint is going to get less than the other half because she's going to take her costs and anything she has advanced, any cost she's incurred, out of his half. So we have a whole bunch of issues here about contingency fees, because that's essentially what this is. She is setting up a contingency fee agreement with Clint. And so I need to focus in on contingency fees. The problem with those is that although we tolerate them in California, they mean that the attorney has taken a stake, a direct stake in the outcome of the case. And that leads to problems if you're not really careful. She's not going to be really careful. So what do we know about contingency fees? Well, first of all, we know that a flat 50% is probably not okay. Generally, those are structured so that it's 30% at the start and it bumps up to 40% if certain things happen in the case, and it could get up to 50% at trial. But to start out with a blanket 50% is pretty high. Look at what we know about contingency fees here. First, we know that in California, fees must not be unconscionable. That's different from the ABA. Fees must not be unreasonable, and we know what unconscionable means. It shocks the conscience. To shock the conscience, it's disproportionate to the value of the service. And so that has to be tied to the amount of work that goes into the case. and hers is not, so that's a problem. We also know that contingency fees have to be in writing, and we know quite a bit of detail about what needs to be in that writing. So go on to the fact pattern, and we see that Clint orally agreed to this fee arrangement. That is a violation. It has to be in writing in California, and there are extra statements involved, required in California, as opposed to in the ABA rules. So here is our first test of a distinction between California and the ABA, and here we have set up the conflict in the case. She has taken a personal stake in the outcome. She doesn't get paid unless she can get a recovery. She hasn't started working on this case, so she doesn't know how strong it is. She doesn't know what defenses are there for Dan, and she really has no idea of the value of the case until she does substantial work on it. So here we sit. What happens now in this hypothetical? Dan's insurance company, Acme, emailed Linda before Linda completed any substantive work on the case and offered to settle the matter for $100,000. Well, at this point, as I said, she doesn't know the value of this case. And so their offer coming right away is pretty indicative of the fact that they think there's a lot of liability here. They emailed her, so this is a written settlement offer, and we have rules about settlement offers that require the attorney to communicate any significant oral offer and any written offer. She's already got one before she's even started substantively working on it. Not only that, but here we go with the conflict. She needs to collect, and she's already being offered $100,000. So now what happens? Linda was thrilled and replied to the email that she accepted the settlement offer without talking with the client. You can't do that. And it makes it clear that she violated the rule on the need to communicate that written settlement offer, because it then goes on to say, Linda then told Clint about the settlement. That word then is important. She accepted the settlement offer without communicating it to him. That's such a clear violation of the rule. It's the client's decision about whether to settle that or not, and she was required to communicate it. Clint was relieved that the case settled so quickly. Does that solve it? No, it doesn't. She violated the rule. Yes, she was thrilled. She was going to get $50,000 without doing any work or any substantive work on this case. So here in this paragraph, we have a written settlement offer. We have a clear violation of the rules about communicating written offers. And we have an example of how that conflict plays out. She was thrilled. She was going to get 50% without doing any work. Now she knew she was going to bring in fees. See, if I frame it in terms of the conflict, I write a much stronger answer than if I just go down an outline or an issue checklist and click off the rule violations. And they're really hammering the fact that it was almost immediately settled, because they keep saying settled so quickly. All right, now we have Acme delivered a check for $100,000 payable to Linda, who deposited it into her law firm's business account. Into the business account. That's not okay. Now, hopefully you know the rules about client trust accounts in California. Let's take a look at that. Fees. Safekeeping client funds and property. All funds received or held for the benefit of a client must be deposited into a client trust account. A fee paid in advance has to be put in that client trust account as well. So you can't put a settlement into a business account and pay it out of there. It has to go into the client trust account. How you set that up is beyond the scope of the bar, so we won't worry about that here. Know that the bank will help you do that. You just have to choose a bank that knows how to do attorney-client trust accounts. Okay, back to the facts. Linda then wrote a check from that account. Can't do that, has to come from the client trust account, to Clint for $50,000 minus her costs, and mailed it to him. Part of the reason you have to have that client trust account and you have to do everything from that is because if he objects, if there's a dispute, then those funds that are in dispute have to be in the client trust account. She has everything in the business account here. Upon receipt of the check, Clint complained about Linda's fee and threatened to sue Linda for malpractice and report her to the state bar. Well, yeah, $50,000 minus her costs. What costs? She hadn't done any substantial work on the case yet. It settled immediately with no substantial work on her part, and she's going to collect 50%. He gets less than 50% because she claims she has costs. Yeah, he's complained. And that goes to explaining why that flat 50% fee is unconscionable. Okay, then it goes on to say that Linda offered to return $10,000 of the fee in exchange for an agreement releasing Linda from all liability associated with the representation. This is one of those picky issues that's ordinarily not tested on the bar, and that I think made this particular exam really, really difficult. So let's look at the rule, because now that they've tested it once, everybody is going to have to know this particular rule. I mean, we've always known, and I think it's been tested before, that when we're talking about the client-lawyer relationship, one of the distinctions from ABA that California has is that when you think about duties to the client, California has a complete ban on prospective limits on malpractice liability in any retainer agreements. ABA allows them. But in California, you can't put in your retainer agreement before somebody has hired you that you don't bear any malpractice liability. Once retained, then you can do certain things. And one of those things is that you can try to get a release from a current client, which is what he is, for a malpractice claim without any written disclosure if the damages are less than $10,000. Well, she's offering him 10, so clearly she thinks the damages are more than, or at least 10,000. Probably more than that if she's offering him 10. So that third paragraph goes to the client trust account and to the rules on what a California attorney may do in terms of limiting malpractice liability with a prospective client and with a current client. And I would explain in my answer to get more points that it's absolutely forbidden in California with a prospective client, but he's not a prospective client. So there's an on-point rule, which she violated. They gave you pretty clear violations here. This was not tremendously subtle, but I really think the difference between a high-scoring answer and one that gets maybe a passing score, maybe not, is that you show the reader that you understand the context, that you understand that underlying conflict, rather than that You're simply applying individual rules without any coherent understanding. So this was the final essay in the morning session on Tuesday. Difficult session, racehorse UCC contracts, followed by a con law that raised every issue we cover in speech, as well as raising the possibility of analyzing equal protection, due process, other 14th Amendment claims. Not an easy session to end with a PR.